Good evening. Welcome to this talk this evening. I'm Michael Astle. This is Matt Harker, and we're going to talk about conciliated agreements in the Land and Environment Court and a case called Maha. So what I've got here isn't what's on there, so I'm sorry I have to be turning around all the time. Has Maha been taken too far? For those of you who don't know what Maha is, don't worry. We will go to that and tell you a little bit about what it is. For those of you who don't know what Section 34 is, we'll also have a look at that and let you know what the important parts of that is. Then the scary concept, jurisdictional precondition. A lot of people hear the word jurisdictional and immediately freeze up because they think they're going to get Justice Baston talking about the difference between a jurisdictional fact and Wednesday unreasonableness and the like, and some, like me, don't get lost quite quickly.
Yeah, it keeps me up at night.
What has the court treated it as a jurisdictional precondition, which Matt will look at, and finally tips on getting a Section 34 agreement over the line. So, as promised, there's Section 34, hopefully, and it's a number of things to note. It, first of all, is predicated on an agreement being reached between the parties in proceedings. Those of you, and I think it's probably most of you, know what a Section 34 conference is, and Section 34AA is the same. 34AA is a mandatory conference. Section 34 is almost mandatory these days. The court bangs the parties' heads together and makes them go and try and reach agreement to avoid the cost, expense and uncertainty of a fully contested hearing. This provision then applies if an agreement is reached between those parties. So the agreement is reached. Then if the agreement reached is one that the court could have made, not would have made, so it removes some discretion, at least some discretion from the court, could have made in the proper exercise of its functions, and that's what we'll be looking at in more detail, it then, that is the court or the commissioner acting as the court, must dispose of the proceedings in accordance with the decision. So it's in mandatory terms. So we'll have a closer look at what that means. The Court of Appeal in Dartbrook observes that if an agreement is reached, the court's role is very significantly circumscribed. The only issue is whether the resultant decision is one which could have been made in the proper exercise of the court's functions. So what are the court's functions? Again, most of you will be very familiar with what the court's functions are in Land and Environment Court Class 1, obviously to determine appeals, including in relation to development applications, which I'm sure you all know and recognise the abbreviation DAs and MODs, exercise all the functions of the consent authority in relation to the subject matter, and we won't go into that very much, but generally, of course, when the court does make a decision to grant a development application, it is mandatory for the court to take into account all the relevant considerations under Section 4.15 of the Planning Act. And of course, there are plenty of cases where people attempt to overturn council's decisions where they allegedly haven't taken into account all the relevant matters for consideration under Section 4.15. So the court has power to grant a development consent irrespective of whether concurrence, in the case of integrated development, has been obtained, general terms of approval and so forth, vary and revoke conditions and grant remedies which the parties are entitled to. So that's limited in Class 1, of course, and we're not going to get into the different jurisdictions between Class 1 and Class 4, but really this slide is just to show that the court has very plenary powers in respect of Class 1 appeals, and usually when it's exercising those functions in a contested manner, it has to, obviously it gives consideration to the statements and facts and contentions the parties have brought to it, but it's also mandated the court must consider all relevant matters for consideration arising from the development, impacts of the development. So Maha was a case where there was an agreement at a Section 34 conference. The Commissioner, I'll use the word rubber stamped it, gave a consent, and then an objector said, well, hang on a minute, that's unfair. I've been locked out, and objectors often feel like they've been locked out, but in this particular case, the objector had some valid grounds to take up in relation to the the purported consent to activate the agreement reached between the parties. So the decision was challenged in judicial review proceedings by an objector. The three grounds were absence of owner's consent, that is, the owner of the land or not of some of the land in respect of which the consent was to operate had not granted consent to the making of the development application. The second challenge was that there had been a failure to form the requisite opinions under clause 4.6, and those of you who don't know, and I'm sure most of you do, a 4.6 objection is where a proposed development would not conform to the requirements of a development standard, and clause 4.6 permits an objection to be made to a development standard, and provided certain matters are satisfied, the development standard is not given mandatory effect and the development may be approved notwithstanding its non-compliance. So again, this is not a seminar on clause 4.6. That could be the whole topic of another seminar. And thirdly, the ground of challenge was that plans were a mess, effectively, and so that it was unreasonable or irrational to grant consent to them. So Justice Preston of the Land Environment Court was sitting in the Court of Appeal. He said, concentrating on the phrase could have made in the proper exercise of its functions, he said this: a decision that the court could have made in the proper exercise of its functions under the provisions is one which the court exercising the functions of the consent authority has jurisdiction to make. He went on, a development application can only be made for consent to carry out development that an environmental planning instrument provides may not be carried out except with development consent. A development application cannot be made for consent to carry out development that does not need consent or that is prohibited. So that's the first thing he said about it. He went on, was this decision one that the court could have made? He said, the requirement in the EPA Act and regulation that a development application contain evidence of the owner's consent and the requirement in the applicable instrument that development consent not be granted except if some condition is satisfied are jurisdictional prerequisites that need to be satisfied in order for the consent authority and the court to be able to exercise the function of determining a development application by granting consent to the development application. Under section 34.3, if the jurisdictional prerequisites to the exercise of the function of determining a development application are not, by granting consent to the development application are not satisfied, a decision to grant consent to the development application will not be within the phrase in the provision. The court could not make that decision. So what's a jurisdictional prerequisite? And this is where we are of the view that a jurisdictional prerequisite is something that it must exist before that power is available. It is not a matter which is ordinarily relevant to the exercise of the power. And that's the distinction which Matt will look at some of the cases where we think that that distinction has been somewhat lost. So Justice Preston, back in Maha, talks about this distinction a little bit. The check on jurisdiction required by section 34.3 will not usually require the Commissioner to check whether there will be an abuse of power if the power to be exercised in a particular way. For example, the Commissioner would not be required in determining the development application by the grant of consent to take into consideration the relevant matters in section 4.15. The requirement to consider relevant matters is a condition on the exercise of the power to determine a development application, but it is not a condition to the exercise of the power in the first place. The check on jurisdiction required by section 34.3 is that the decision could have been made in the proper exercise of the relevant power. That is to say, there is power to make the decision, not on how the power, if it can be exercised, should be exercised, going back to the removal of the discretion that I mentioned at the outset. So in relation to ground one, and I won't read this out, it's basically saying the grant of owner's consent is necessary to enable the consent authority to exercise its function to grant development consent to the application if it is minded to do so. And as most of you will know, owner's consent is a mandatory prerequisite, or one of the things that must be within a development application for it to be a valid development application. Of course, there are other mandatory requirements in a development application as well set out in the regulation. I think it's where they are now. So because a consent authority can't run around just granting development consents, before the power to grant a consent is enlivened, then there must be a valid development application in the first place. So that's the first ground. In respect of the second ground, Clause 4.6 is in the following terms: development consent must not be granted for development that contravenes the development standard unless the consent authority is satisfied about certain things, and the provision, of course, or the clause goes on and on. This is a jurisdictional fact of a special kind, as observed by the Court of Appeal in Palace Newco, and it is a precondition to the exercise of the power. And again, the challenger to the consent granted in Maha was successful on that ground. Ground 3 got short shrift really in the Court of Appeal because the first two grounds were clearly made out, so they didn't really have to give much attention to this. So Justice Baston, which is obiter, made some observations about the provision, and then he said if the development application lacked essential elements, the deficiencies could render a consent one which could not have been granted in the proper exercise of the court's functions. And that's going back to the point about the mandatory content of a development application. He then said, however, Maha framed its ground as a challenge based on the legal unreasonableness of the consent. It is not necessary to determine whether this was an appropriate formulation of the ground, nor whether the deficiencies in the plans were such as to allow them to be characterised in that way, and basically didn't deal with Maha succeeds on other grounds. Justice Preston said something about this. He said, again, referring to the quote that I had on the earlier slide, it does not usually require the Commissioner to check whether there will be an abuse of power. And then in relation to this ground, Maha contended the Commissioner's decision to grant consent lacked certainty and was legally unreasonable. The check on jurisdiction required by Section 34.3 of the Court Act required the Commissioner to determine whether the development application with these deficiencies was a development application that answered that description under the EP Act and regulation. This is because the power in Section 4.16 is to determine a development application. So they both really, in a way, ducked the question about about whether the Commissioner was obliged to act in a reasonable manner or whether it was reasonable for him to view the plans as being adequate and so forth. And they reframed the question about whether the plans were such that they constitute a part of a valid development application. And they'd already decided that it wasn't because it didn't have owner's consent, so didn't really need to go into that ground very much in detail. So we think that really the concern is with essential statutory prescriptions, in particular with a development application. So if you wanted to challenge in future on the basis that the plans were inconsistent or unclear, you would have to, it's a fairly high hurdle, we think, you'd have to tie it back to them being so bad that it meant that the development application didn't constitute a valid application. So what is a precondition to the exercise of the power? Obviously a valid development application. Owner's consent's part of that, as opposed to being a separate requirement. But all the formal requirements of a development application are necessary. That would be a precondition. A valid clause 4.6 objection and a state of satisfaction in relation to it, because the clause 4.6 mandate is not only that you have a section 4.6 objection in respect to which you can tick a box, but there is a mandated state of satisfaction in relation to it. In relation to modification applications, a precondition to the exercise of power would be that a state of satisfaction that the development as modified will be substantially the same as the development prior to modification. And jurisdictional requirements, obviously permissibility, that is that the development is permissible in the zone, etc. And clauses that are framed in that kind of formulation, development consent must not be granted unless something. Those are, we think, jurisdictional prerequisites to the exercise of the power. So That's how we think it works, and has the court conformed to what we think the way of the world is? Well, perhaps not. And I'll hand over to Matt to go through some through this part of the talk, and he'll talk about some cases where the court has taken a rather more broad view of things.
Yes, and why that view is actually incorrect. So, as we know, since Maha, there's been a very intense focus by commissioners on ensuring that essentially an agreement is one that they could have made in the proper exercise of their functions, as the requirement that Mike pointed to before. But also with that, there's been provision of detailed reasons by commissioners when disposing of matters under Section 34. And that's provided an insight into what commissioners regard as jurisdictional preconditions on the exercise of power, as well as our own experiences, which are slightly different to what Chief Justice Preston indicated were jurisdictional preconditions in Maha. So I've pulled out a few examples from just the last 2 weeks. First one, I'm not going to name names, but the first one, this is a judgment where essentially it was a DA for a residential subdivision. The commissioner went through the relevant jurisdictional prerequisites like permissibility, the presence of a detailed site investigation under the resilience and hazards SEP and so on. And then goes on to say, under the heading jurisdictional considerations, this in relation to section 4.151, that mindful of subsection 1A3, I've given consideration to the DCP, notes the advice of the parties in relation to public notification, and is also given attention to the likely impacts of the proposal, site suitability, and the public interest, all matters which the court, if it determined the matter at a hearing, would be required to consider under section 4.15. But as Mike indicated before, Preston dealt squarely with this issue in Maha and whether a court was required to consider it. So do we think, from what we heard before, is 4.15 a jurisdictional precondition? I think the answer to what the Commissioner did here is very simple, and I'm going to leave someone who I'm sure we all detest to indicate what the answer is. That didn't get through our marketing committee, so it may be deleted when it goes online. Another example, slightly different, is this decision which was handed down on Tuesday of this week. It was a development application for demolition, subdivision, and the constructions of 2 dwellings with, importantly, a basement level. And the basement was significant because it gave rise to a need for earthworks. And as we know, those of us who practice in planning, there's a provision in the standard instrument that says that a consent authority must consider certain things before granting consent where earthworks are involved. So the Commissioner went through the usual preconditions, permissibility, development standards, 4.6, so on, and got to these 2 points. First one considers the matters in 6.23, which deals with earthworks, and I'll take you to that in a moment. And secondly, considers the the matters raised in the submissions of the objectives. That's a matter that's dealt with in section 4.15, and as we know from Mr. Trump, it's not something that is a jurisdictional precondition to the exercise of power, the consideration of those submissions. But the earthworks provision is slightly different, and this is it here. It says, before granting development consent for earthworks, the consent authority must consider the following matters, such as disruption and detrimental effect on drainage, quality of fill, and so on. This is not a provision like 4.6, the example which was included in Maha, which is that the consent authority must not grant consent unless it reaches a certain state of satisfaction. This is simply, before granting consent, it must consider. It is a mandatory relevant consideration, which, like the matters in section 4.15, is a condition on the exercise of power. So that when you're carrying out your assessment of a DA, it's something that you need to consider. It goes to the manner in which the power is exercised, as opposed to opening the doors to enable you to exercise power. And that's what the court has said in Maha, Palace Nuco, in relation to jurisdictional facts. When you have a requirement that you must be satisfied of a particular matter, and you must not grant consent unless you are satisfied of that matter, that opens up the doors to the exercise of power. This is slightly different. It just says you must consider it, which is completely aligned with 4.15, which the Chief Justice says in Maha is not something that is a precondition to the exercise of power. But there's another reason why commissioners probably shouldn't be considering these matters and disposing of matters under Section 34. And that is, remember that 34 says that a commissioner must dispose of the matter in accordance with the agreement of the parties. There's no scope for them to consider the merits, consider if the agreement is one which reflects a decision that should have been made by the court. It's just that it could have been made by the court. Which raises the question, when these provisions say must consider, and the court is saying that they are considering, what is the court actually doing? And there's a lot of authority going back a long way, particularly in administrative law and in migration cases, about what consideration entails. It's a decision from the 1980s by Justice Gummow, which is repeated quite often, which says that consideration means proper, genuine, and realistic consideration. And that was considered by the Court of Appeal in a case of Wheel and Bathurst City Council in the planning context. And President Mason had this to say in relation to the duty to take matters into account. The duty to take noise into consideration required more than simple advertence to the noise issue. I agree with Justice Giles that there had to be an understanding of the relevant matters and their significance to the decision required to be made, as well as a process of evaluation sufficient to warrant the legal description of the matters being taken into consideration. Legally sufficient consideration of the noise issues extended to consideration as to appropriate conditions, limiting and controlling noise if consent was to be forthcoming. Essentially, consideration requires the court to do the very thing that it is not supposed to do in disposing of a matter under Section 34, and that is to consider the merits, consider if the conditions that are proposed by the parties are adequate, and ultimately interrogate the actual agreement of the parties. Because ultimately, under 34, once an agreement is reached, the merits of that agreement is completely out of the hands of the parties. And so if the court can't consider the merits, it suggests that it can't engage in consideration, which tends more closely to Preston's approach as opposed to Justice Baston, that matters in terms of the abuse of power are not things that are relevant for the court to consider at the Section 34 stage. So it doesn't consider whether a decision would be legally unreasonable, except for perhaps it may be an obvious case. We were talking about that before. There may be some scope there to make that argument. But also that it wouldn't extend to a consideration of whether of matters that a consent authority is required to take into account, like under Section 4.15 and like in relation to the earthworks condition. And just taking you back to that provision in Maha, and Chief Justice Preston says it very, very clearly. And it's a really useful paragraph of Maha if you ever get questioned by a commissioner in terms of whether something should be considered or not. And he says that the requirement to consider relevant matters is a condition on the exercise of the power to determine a development application, but it is not a condition to the exercise of the power in the first place. Check on the jurisdiction required by 34.3 is that the decision could have been made in the proper exercise of the relevant power. That is to say that there is power to make the decision, not on how the power, if it can be exercised, should be exercised. And just to give you an example of how useful this provision is, just before Christmas, I had a hearing that settled on day one. And the council was subject to the direction and control of the planning panel. And the planning panel indicated to them on day one, yes, you can enter a Section 34 agreement as long as the jurisdictional statement addresses the earthworks condition, the earthworks clause in the LEP. Of course, as soon as I got that, I was like, oh, geez, it's not a jurisdictional precondition. We shouldn't have to deal with it. But as some of us know, when you're dealing with a panel, sometimes you have to bow to their demands in order to get a matter over the line. So what we did with the agreement of the council is we included the matters concerning the earthworks condition in the jurisdictional statement, but we opened the discussion of that with this is not a jurisdictional precondition, and we said why, invoking this clause of Maha. And the Commissioner agreed, and it's not something that you'll find that's ultimately dealt with in the judgment, which I say is probably an example of the Commissioner actually properly following what is required to do, what the Commissioner was required to do in Maha, as opposed to some of the other examples in terms of 4.15. Now, to give you another example from the last week, is this decision, Cara Alley and Hawkesbury City Council. That was a case that involved land clearing, earthworks, and the construction of a dual occupancy. So the court went through standard preconditions, permissibility, didn't deal with earthworks. So this is probably an example where the court's taken, at one point, the correct approach. And then says this: the parties have had regard to the relevant provisions of the DCP. They've had regard to the clauses in the SOFEC and those in the particularised in the contentions. And the court is satisfied that the proposed development can be approved as the parties have had regard to the provisions of the DCP and 4.15. Now, for those of you here and those at home, can any of you see any problems with this? I can see three. Firstly, consideration of the DCP is not a precondition to the exercise of power. It is a mandatory relevant consideration that's dealt with in section 4.15. So it's not a matter that goes to, as I said before, the doors of power being open. It's not a matter that the court needs to consider disposing of a matter under section 34. The second point is that even if it was, the parties can't simply agree that the court has jurisdiction. And that, I'd restrain myself by not putting in some 1880s case law, as some of those here know that I have a penchant to do. But in AQC Dartbrook, Justices Maha and Leeming make this abundantly clear. They say that it's tried that a court must always be satisfied that it has jurisdiction before exercising jurisdiction in a matter. The court must always be satisfied before making an order that there is power to do so. The fact that the parties agree as to jurisdiction or power does not avoid the need for the court to be satisfied. And this is something to take into account when you're preparing your jurisdictional statements as well, because often you'll see statements that just say, well, the parties agree that this is satisfied, therefore the court should be satisfied. Query, how is that going to help the Commissioner? Which comes to my third point here, is that whether somebody else has a view is usually irrelevant. In this case of Smith and the Queen, which I've included up there, it's not necessarily that old, it's 2001. It's an evidence case which concerned the admissibility of identification evidence by police officers. So two police officers gave evidence in the box. They looked at CCTV footage, and looking at that CCTV footage, the perpetrator in there was the accused who was sitting in the box. In reliance upon that evidence, the accused was convicted, and that conviction was ultimately overturned in the High Court. And the High Court said that the police officers were in no better position than the court because they had the same material available to form a view in terms of whether that person was the perp or not. So the process of reasoning could not have been assisted in any way because the judge, or the jury, I'm not entirely sure what it was, but were merely substituting their view for the view of the police officers. Because purely because somebody has a view doesn't necessarily mean that that is the right view. And in the terms of Section 34, if an applicant says that something is satisfied, how does that help the court? Unless they have some particular expertise which the court can rely upon. An applicant who's often a developer, it could be a mum and dad developer, is in no more special position to the court that qualifies them to set a particular view. So when you're doing your jurisdictional statements, I think, and I'll come to this at the end, don't just say the parties agree, because that doesn't help. What's useful is to say the parties agree and why the parties agree, because then the court can actually assess the reasoning and it can form its own view. Or if it's the opinion of an expert, you can say, these experts have reviewed it, they have this view for these reasons. And then the court can form a view whether it agrees or not. Because otherwise, it's just abandoning completely its decision-making function and just saying the parties say so, therefore it's okay. Which traverses not only Smith, but more importantly, what Justices Maha and Leeming say in AQC Dartbrook. Now I'd like to put to you potentially a different formulation that a particular solicitor in this room has tried to pull against me in a 34 before. Yes, that one. And that is, considering Section 34 says that the court needs to be satisfied that the decision is one that it could have made in the proper exercise of its functions. So when you're dealing with must consider provisions and Section 4.15, why isn't the question for the court, if it has or doesn't have sufficient information to have been able to have considered the relevant matters? So does the court need to look at the documents and say, oh, like, if I had to decide it, I could have decided it because, for instance, if the issue was overshadowing, I had shadow plans and I could rely upon those. And this aligns, I think, a little bit more closely with what Justice Baston said in the Court of Appeal, that the court needs to be satisfied that it is a decision that's not going to be overturned in the Court of Appeal. And that can be for many reasons, like unreasonableness or otherwise. But I want to answer that question with a different question, pig unreasonableness. And that is, does the court need to be satisfied that any decision would have an evident and intelligible basis or not otherwise be unreasonable? And this is the very point on which Maha did not get up. Got up on everything else. This one, Chief Justice Baston avoided it. Chief Justice Preston ducked and weaved a little bit, but ultimately said the question was whether it's a valid DA or not. But he made it clear that the court, in exercising functions under 34, doesn't need to determine whether there would be an abuse of power or not if consent was granted. So why is there any difference between what Preston said about this and consideration? Both are conditions on the exercise of the power. Maybe if it was clear and obvious that certain matters couldn't have been considered. For instance, if you've got a DA for a house and there's no plans for the house, although I beg the question whether that's a valid DA or not. But once you go beyond that, you risk the court risks interrogating the merits too closely, and that's something which it really isn't supposed to do in Section 34. It's just supposed to form a view it has power and then grant consent irrespective of the merits of that decision or not. And again, just to drive it home, these two paragraphs of Preston's judgment, which we've come back to a couple of times, they're incredibly important and they're incredibly useful, particularly if you're an applicant trying to get a DA over the line. And again, the first paragraph is incredibly important. The check on jurisdiction required by section 34.3 will not usually require the Commissioner to check whether there will be an abuse of power or if the power were to be exercised in a particular way. And then he goes on in terms of the unreasonableness grounds to consider it purely in the context of whether there was a DA, whether there wasn't. So ultimately, it appears that the commissioners, in some respects, may perhaps be taking Maha a little bit too far in insisting upon the satisfaction of matters that they do not need to be satisfied on. For instance, that the submissions of the objectors have been dealt with, and considering the impacts, considering the impact of earthworks. So what can you do next time you front up before the court, particularly if you're an applicant, to get your Section 34 agreement over the line? We've got a few tips for you now. First one is more of a general tip, and that is identify your jurisdictional preconditions as early as possible. If you're briefed by an applicant, it should be one of the first things you do, because the last thing you want is to be on the eve of a hearing and to find out you need a beta. Because as we know, as Liam is indicating, you haven't done your job properly if you're finding that out the day before. But they take months. They require surveys that sometimes can only be done in particular points of the year. And it's not something you can get in 2 weeks, and it's not something you can get in a month. It could be 2 months at the earliest if you are lucky. So if you get ahead of it and you identify it at the outset, you put your client in the best possible position to have it dealt with prior to the hearing and ideally get an approval. Second one is use the council's assessment report to your advantage. Often, and there's a lot of gold in council assessment reports because they'll often only refuse things for 1 or 2 reasons, but they'll deal with every single jurisdictional precondition, hopefully, in the assessment report. So when it comes time to get your Section 34 agreement over the line and the court wants to see evidence of some particular matter, you can say, well, turn to page 5 of the assessment report. It's been dealt with by the council planner, it's been dealt with by the council engineer, and these are the reasons why it's satisfied in relation to the DA. And a lot of the time, that will really, really assist the commissioner. Talked about it before. Avoid simply saying the parties agree. Try and give some examples, because ultimately, if you get a judgment from the commissioner that just says the parties agree this, therefore I am satisfied, you have those problems about the parties agreeing jurisdiction, and if you have a particularly active objector, that is just a clear invitation for them to front up in the Court of Appeal and seek judicial review, probably successfully, of the consent that you thought you'd got over the line in the Land and Environment Court. Next one is to prepare a bundle. Often when these things settle before a hearing, you won't have a bundle, but the commissioner still needs to be pointed to evidence that all of the preconditions are satisfied. And to have that evidence at your fingertips is incredibly useful. The court will be incredibly grateful for it, because ultimately our job is not only to act for our clients and act in the best interests of our clients, we have an obligation to assist the court. And assisting the court, the best example of doing that in this context is just creating a mud map for them, but where the evidence is, how every precondition is satisfied. So although they won't do a copy and paste, but they can sit down and quickly and easily draft the judgment, and you can get your approval faster. On that point, point to the evidence in your jurisdictional statement. This is something that I like to do, and I found it quite effectively, is to use footnotes or some form of referencing in your jurisdictional statement and point to pages of the bundle. When you're sitting down and you're taking the commissioner through why the court has jurisdiction to make the decision, you already have at your fingertips where the relevant references are and where the evidence is in relation to each jurisdictional precondition. It's very helpful, and the court will definitely thank you for it, because when they go away and they have to write it, they've got it on paper already, which documents they need to look at. Next one is stand firm on what is not a jurisdictional precondition. like the earthworks condition. If you have a council that is insisting that something go in a jurisdictional statement and you won't get it over the line if the council doesn't do it and you haven't been able to persuade them, put it in and include a statement to the effect of the applicant submits that this is not a jurisdictional precondition for these reasons. And most of the time, you'll be able to do that by deploying Maha, and in particular, Preston's judgment at paragraphs 217 and 218. They're incredibly useful. And when the commissioners see the judgment of the Chief Judge saying that I do not need to take into account the matters in section 4.15, it is a very powerful reason for them to then say, well, I don't need to do it, and I'm not going to do it, and I'm not going to cross in something that I do not have to. Because ultimately, you need to remember that when these agreements, when these decisions are being issued, that if you want to modify your development application in the future, those reasons could be relevant because there's a requirement in considering a modification application for a consent authority to consider the reasons why the consent was granted initially. Sometimes the less information in these documents, the better. So if you can avoid dealing with certain matters such as the impacts of the development, the objections, and whether the DA responds to the objections, then that may facilitate your client getting a modification in the future because it's not confined by any reasons that were given by the court in disposing of a development application. So those are tips I think that are really helpful, I hope. But if you have any questions for us, I think we're at that point.
Just one other thing that we've concentrated on Class 1 here, but I heard from a solicitor today that this virus or whatever it is spreading into Class 3 settlements. So I heard today that a commissioner was requiring, before endorsing an agreement on a Class 3. Class 3, of course, is compensation following compulsory acquisition of land, and it's just a question of how much money you get. But a commissioner had apparently required a jurisdictional statement, which I would have thought consisted of there was a compulsory acquisition gazetted and we made a claim and we want this much money. But I was told that the jurisdictional statement required them to go back to show that the acquiring authority had complied with section 10 capital A, which requires 6 months negotiation before publishing in the Gazette. And that's just obviously wrong because in Class 3 the court has no jurisdiction to inquire about the validity of the acquisition itself. If you want to do that, you've got to go up there. So it is a concern, and I don't know what the answer to it is. The answer to it, I suppose, is for an applicant, and it's very unpalatable to do so, to stand their ground and refuse to have jurisdictional statements and then seek some sort of mandamus against the commissioner to get the consent. But that's obviously probably not in the best interest of your client on any particular occasion. And so the solution that Matt's outlined, put it in, but put a footnote disclaiming it is probably the better thing for your client on a particular day. So just
it works. I mean, if you put it to them and you take those paragraphs to Maha, sometimes they'll step down.
Matt, are you saying, I would normally in my section 34 jurisdictional statement, I wouldn't use the words the parties agreed, but I would say that the Commissioner can be satisfied that the matters in section 4.15 have been addressed and identify where in the evidence that might be. Are you saying that you don't even need to go there?
Yes, you don't need to go there for 4.15, and Preston makes that really clear in Maha. It says they're mandatory relevant considerations, not a precondition to the exercise of power, so it's not something that the court needs to consider. Sometimes if you're acting for councils, you like to put it in there because it shows for the objectors that these things have been dealt with and they've been considered, but it's just ultimately for commissioner's purpose completely redundant. And if you're an applicant, it's probably in your interest not to have it in there. Cool. Any questions from at home, Matt? No? Okay, well thank you particularly for those who have come in. I know I sledged one of you, but it's absolutely a pleasure seeing some faces here, and thank you for those who now have tuned in online. It's been a pleasure. And, yeah, thank you.
Thank you all.